Hi, Rishi, you can hear me, right?
Yes, I can, Stephanie, loud and clear.
Should we start now or like maybe a few more minutes because participants are coming in?
I think we can start. It's 2:30. We just go ahead.
Yeah, okay. So I think we shall start now. Ladies and gentlemen, a very good afternoon to all of you. Thank you for tuning in and welcome to RDS's Thursday webinar session. I'm your moderator for today's webinar. My name is Stephanie, an associate under the RDS Dispute Resolution Practice. Here with me is Mr. Rishi, who will be the speaker for today's webinar. The topic of today's webinar is Formulating and Main Action Strategies in Intellectual Property Litigation. A bit of IP litigation. IP litigation are very often infringement cases, for instance, counterfeit products, the use of confusingly similar marks, unauthorized use of publication materials, unauthorized use of artistic materials, so on and so forth. Very often, these are only realized after serious damage had been occasioned on the IP owner. As a result, pre-action injunctions are very important tools to ensure that infringing acts can be halted with the quickest effect. At the same time, ensuring that evidence of infringement are not destroyed. These are often crucial evidence and may be determinative of the outcome of your IP litigation because the burden to prove lies mostly on the plaintiff, which is usually the IP owner. To prove infringement, including infringing acts, the purported infringing products, profits gained by infringement, so on and so forth. The focus of today's webinar is therefore on the various tools and strategies to safeguard the rights and interests of IP proprietor. The discussion will be a comprehensive and complete one, which covers also preparation for trial as well as settlement strategies in an IP suit. Before that, let me give you a brief introduction of our speaker today. Mr. Rishi is a partner of the firm's dispute resolution practice. Rishi was called to the English bar in 2010 and subsequently to the Malaysian bar in 2012. Rishi has vast experience in civil litigation, specializing in corporate and shareholder disputes, corporate fraud disputes, and defamation suits. Rishi has appeared at all levels of Malaysian civil courts. Amongst others, Rishi is currently involved in a number of high-profile civil suits relating to 1MDB. Apart from court battles, Rishi also actively represents clients in domestic as well as international arbitration. Often known as a solution-driven lawyer, Rishi has now acquired a substantial clientele base, including financial institutions, leading audit firms, newspaper, multinational and listed companies. With that, I believe Rishi's experience and knowledge has made him the perfect person to speak in today's webinar. Before that, in this webinar, you all can leave your question in the comment box or the Q&A box. Rishi will address the questions at the end of the webinar. For those who are watching through Facebook Live, feel free to also leave your questions at the comment box below. So I think without further delay, I shall now pass the floor to Rishi. Over to you, Rishi.
Thank you very much, Stephanie. Good afternoon, everyone, and thank you for joining us today. Thank you for the generous introduction. I'd just like to make one remark in relation to that. I don't know whether I'm the perfect person to be talking about IP litigation. I have to put it out there as a caveat at the start. But I suppose when the firm had asked for me to talk today, it is to share insights insofar as pre-action strategies are concerned. And I was meant to do just that. However, the very last hour, the 11th hour, I was informed by my colleague who was meant to be the other speaker to cover the main action strategies and particularly the nuances of what IP related litigation calls for. He is unable to join us today because he is at the Court of Appeal and the hearing has been extended. So I will endeavor to do my level best in so far as covering both aspects with the nuances of what IP litigation is. but do bear with me if it is some aspects of it are not as technical as one would expect. Having said that, I will start my the presentation by going through what we have set out as an agenda. The agenda is, first I will touch a bit on pre-action strategies in relation to IP litigation, and that will include speaking about a very popular preemptive remedy, which is utilized by lawyers or litigants intending to secure rights in relation to IP. That is the Anton pillar. And then touching a bit on other injunctions which do feature as well in IP litigation, that being the Rinford Injunction and the Time Injunction, and recently we have the Springboard Injunction. And then we will go on, of course, when I am discussing these pre-action strategies, I would also be going into what are the criteria insofar as litigants, what the criteria that litigants ought to be aware of before embarking on utilizing such a method for redress. And then we will go on to discuss a bit on main action strategies and it's the typical cause of what happens in litigation, but what are the additional considerations when it comes to IP litigation. Then in discussing main action strategies, we will touch a bit on key evidence in IP infringement actions and discuss a bit on settlement strategies when it comes to IP litigation. From what I gather, settlement strategies, more often than not, when in IP litigation, ought to take into account certain key factors, and we will get into that very briefly. Okay, moving on, I will discuss a bit on the importance of injunctions as a pre-action strategy, and you can see we have listed down quite a few factors, and the main thing there is it restores the status quo. For IP infringement cases, the idea is to ensure that the cease and desist takes place immediately, and then every other aspect insofar as business for the person whose rights are being infringed is restored. And it is actually a far and wide concept because more often than not, the party whose rights are being infringed has its business which is going on, and you would like through the injunctions prevent the infringer or alleged infringer from continuing to either infiltrate the market or taint your business in any way. So this is one such method that parties use for purposes of ensuring that the state of affairs is preserved, at least at the interim until the main action. And then we go on to the fact that it halts the infringing act. I covered that already. It provides parties with a preview of the opponent's case. Now, well, this is said in a very simplistic manner, but it is just to ensure, more often than not, when a party decides to go for an IP infringement litigation or IP to protect IP rights, they already ought to have such assessment conducted in a comprehensive manner at the very beginning. It ought to be the case that the advice is that the pursuit of this cause is somewhat resolute. So when we say that it provides parties with a preview of the opponent's case, it's just to make sure that we complete that aspect of what we say as resolute insofar as the assessment is concerned. What is it that the infringer has to say? It is very rarely the case that the infringer has a very strong defense, not Not that it is never the case, but it is very rarely the case. It is usually or typically the case that it's outright infringement by the infringer. Then the next we have cases are consequently often settled or concluded without a trial. This goes without saying. We will touch on this later. Cost effective as they are decided urgently and without a full hearing or oral evidence. Well, this not to say that there is not a cost or perhaps a somewhat substantial cost involved when seeking for Anton pillar relief, but as opposed to or vis-a-vis a full trial, it is cost effective. And when the idea is that the moment the Anton pillar order is obtained, the parties come to the discussion, to the negotiation table to seek and resolve the matter through settlement. A strong prima facie case is not required. Okay, moving on. Now, a bit on the injunction itself, Anton pillar. When deciding to institute proceedings, one must be certain that he or she has or is able to secure the requisite evidence. I have said this earlier. And that is a very key feature insofar as litigation, IP litigation is concerned. It is not the case as sometimes in other types of litigation where you file the action and certain aspects of the evidence in which there are gaps or it is missing, you can go for a discovery action in the cause of proceedings. But when it comes to IP litigation, it ought to be the case that you are secure with your evidence from the outset, especially when it comes to the fact that you are considering to file a Anton pillar order, and the court is going to assess and scrutinize the existence of the evidence as basis with a very fine-tooth comb in sufficient detail to see whether you are entitled to an Anton pillar injunction. Now, evidence such as audio and video recordings, master tapes, computer software, electronic calculators, and documents are easily destroyed or concealed. So that is why people would opt for Anton pillar orders. For example, in copyright infringement claims, more often than not, infringers work in an organized network with the individual retailers at the bottom. So once the retailer is served with a writ, usually after a track purchase, he may quickly dispose of the infringing items to another trader and declare that the infringing materials discovered by the plaintiff were the only ones he or she had. Now, one thing to understand and appreciate when it comes to infringement claims, prospective infringement claims, the infringers are very, very crafty creatures. It normally is, it depends on the extent of their operation. They have a very detailed modus operandi, and they, more often than not, depending on the size of the perpetration of their infringement, they have a sizable workforce, they have an SOP in line to react to how the downline, so to speak, is supposed to deal with situations when the authorities and enforcement agents are conducting a raid or a mystery shopper is in the presence and there is suspicion of that. And one such example in which I was personally involved in an IP matter was when infringers, they were alleged infringers of counterfeit beers, and their modus operandi was that the beers were stored in trucks. So when the enforcement agents came, and when we came with the supervising solicitor with the Anton pillar order, the modus operandi, which was executed immediately, of course not successfully, was for everyone to just start the trucks and move away from that place. So as you can see, it was what one would have typically expected is that the goods, which are the counterfeit goods, such as the beer, the counterfeit beers, were stored in a place, and we were going to go there and seize. But no, they had thought in advance. And like this, there are a lot of other crafty methods in which deployed by the infringers, and ought to be a lot of input assessment at the very start insofar as how everything is going to be counted or how it's going to be dealt with insofar as either retrieving and preserving the evidence for purposes of the trial or action. So that is why we have Anton pillar. The idea of Anton pillar is that although it can be viewed as somewhat an oppressive tool if misused and abused, but it is to ensure that the plaintiff is not left with nominal damages relating only to number of infringing items proved by the trap purchase, for example, the one I just referred to. News of the legal proceedings. Now, when it comes to dealing with Anton pillar injunction, news of the legal proceedings against the potential infringer would quickly get to the supplier, who may disappear at much the same speed, thereby frustrating the owner's efforts to cut off the ultimate source of infringing the goods. That is another big aspect of consideration, and for purposes of effective execution for the objective of outcome, this ought to be taken into account, and the Anton pillar is supposed to preserve that aspect so that the identity of those who are in the supply chain would be sourced, would be retrieved or recovered. So this is where pre-action, the major advantage of Anton pillar lies not in its speed, only in its speed, but on its ability to take the defendant by surprise, so that they do not have an opportunity whatsoever to dispose of infringing items and documents. The preconditions to be met, as laid down in the Anton pillar case, as you will see in the slides, that there must be an extremely strong prima facie case. The damage or potential or actual damage must be very serious for the applicant. There must be clear evidence that the defendants have in their possession incriminating documents or items, things that there is a real possibility that they may destroy such materials before any application, any ex parte, inter partes application can be made. Now, I have had previously on occasion been involved in a case where it was a main technology company, which was printing technology company, which was dealing with a situation where their cartridges were being counterfeit cartridges were being sold, and an Anton pillar was sought, and the assessment insofar as there being evidence of the defendants having in their possession was something the court undertook to go very deeply into before even ordering the Anton pillar injunction, or allowing the Anton pillar injunction. So the scope of the Anton pillar order has widened from searching the defendant's premises and seizing infringing materials to obtaining various information. This can be seen in the case of the EMI Limited case against Sarwar and Haidar, including names and addresses of suppliers, places of manufacture, distributors, retailers, places of storage, invoices, records, and documents, and restraining the defendant from disclosing, without the plaintiff's permission, the subject matter of the proceeding, so as to prevent advance warnings being given to the suppliers. The idea is that the purpose of the litigation is not stultified, it is not eroded. So if it is frustrated, and there are very, very easy methods of frustrating an IP litigation, and that being the supply chain downline. So this is the purpose of this preemptive relief. So one such recent case in which an Anton pillar order was successfully obtained is the Watermac Engineering Sendrian Berhad against Nova Viro Technology Sendrian Berhad. The court held that as regards the Anton pillar order, they were in agreement that the learned trial judge was correct under the circumstances, to grant the order as applied for by the plaintiff and not to have it set aside, the risk factor that the defendants may destroy or cause to be destroyed the incriminating evidence was not one that was merely playing in the mind of the plaintiff. The various documents that were obtained as a result of the enforcement of that order had brought significant advantages that had helped decipher the problems. So there we are, pertaining to the issues at hand between the parties of immense importance in our view must be the drawings recovered from the defendants, from which the ensuing cross-examination of the relevant defendants' witnesses had led to the revelation as regards the true source of the so-called USB system, which the defendants had claimed to be entirely different from the CSTR system, which had its genesis in the works of SPI for his employer Kik Singh, and for whose use the plaintiff had been paying licensing fees to Kik Singh. So in short, it just goes to show that without that sort of freezing effect, seizing effect at that point in time using an Anton pillar, the trial would have been futile, because putting up a witness on the stand for cross-examination and just putting questions to them without basis, without reference, in this case, the documents which were seized during the Anton pillar process, would have rendered the entire trial a waste of time. Moving on, that is insofar as Anton pillar is concerned, a very, very powerful tool if used rightly. A lot of groundwork to be done at the start, but when done right, is expected to at least preserve the prospects of litigation being successful. As I always will mention, say when a party who feels that their IP rights have been infringed, it more often than not is the case that that evidence is there in existence. It's just the assessment of how to make sure that such evidence is retrieved, preserved, and what is the basis of saying that such an evidence exists. So these are the assessments which are to be undertaken at the onset, from the onset. Moving on, we have two other injunctions that I'll touch on very, very briefly, and that is the Rinford Injunction. And this injunction is normally an injunction obtained upon, or in the case, the Anton pillar order, or an Anton pillar injunction, or an injunction in general, is unsuccessful. So when pending the appeal of that Anton pillar injunction, the litigant through their lawyers who ought to move the court for a Rinford injunction to preserve, again, the status quo, pending what the Court of Appeal would decide otherwise, should there be prospects. Of course, the preconditions are slightly different, and this is stated in the case of Xiao Mun Yao against Pan Global Berhad, which the considerations are whether there is a likelihood of a successful appeal being rendered nugatory unless an interim order is granted to preserve the status quo. So the question is, would the appeal be rendered useless or inapplicable or academic should the Rinford injunction not be granted? More often than not, when it comes to IP infringement cases, if there is ex facie evidence to show that there is a prospect, or perhaps they did not meet the threshold insofar as obtaining an Anton pillar order is concerned, and that is the view of the High Court or the judgment of the High Court, an Rinford injunction may have prospects. Nonetheless, the court should also consider whether there is a reasonable ground of appeal and whether there are special circumstances justifying the grant of an Rinford injunction. And this successful usage of this injunction in an IP infringement case can be seen in that Philip Morris brand Stahl against Goodness for import and export and others. Number two, it's a 2013 case. Plaintiff's application was allowed, which in effect battled the imminent danger that the first defendant will at any time between the time of the dismissal of the application till the appeal remove the plaintiff's intellectual property, the Malimbo cigarettes in that case, from Malaysia. This in event prevented the plaintiff's claim from being nugatory, as the substratum of the appeal would have otherwise been destroyed, and the subject matter of the said writ and statement of claim would no longer have been in the jurisdiction of Malaysia. Right? And then we have finally quia time injunctions. Now, quia time injunctions under normal circumstances are used in situations where there are attempts to stultify the jurisdiction of the courts. But in the context of IP infringement cases, it is somewhat slightly different. And the factors to be considered when granting this sort of injunction is the degree of the probability of apprehended injury, the degree of seriousness of the injury, the requirement of justice as between the parties. Of course, the case mentioned there is for purposes of putting into context when is quia time used in the IP litigation scenarios. And in that case, it was a Singaporean company as a plaintiff. The court exercised its discretion under Section 52 sub 3E of the Specific Reliefs Act to order a perpetual quia time injunction to restrain all the defendants from future infringement of registered portcullis trust net trademark in Chinese characters. This exercise, the exercise of the discretion, was premised on the history of litigation between the parties, there being a real likelihood that the defendants may use the said trademark in future, leading to future litigation regarding the said trademark, and the necessity to prevent a multiplicity of judicial proceedings within the meaning of Section 52(3). So quia time relief was slightly stretched, and that is my opinion, in keeping with the idea of stultifying, or the underlying principle of stultification of the jurisdiction of the court. I said there is actually one other injunction that we will be touching on, and very briefly as well. Very recently, in the case of Juris Technologies, the Springboard Injunction is something which is used in scenarios where employers are seeking to protect their copyrights from being infringed or threatened to be infringed by former employees to springboard their interest to the detriment of the employer. And of course, there is always an overlap between causes of action in such situations where it involves a breach of trade secrets, confidential information, exploitation of all of this. It features in a presentation of a writ under those circumstances. So in Juris Technologies, the injunction was granted to restrain the defendants from developing and exploiting the 6 defendants' programs for a period of 3 years. Okay, moving on. I think that is all insofar as pre-action strategy is concerned. We will move on to discuss main action strategy. I'm just getting someone to load up the slide for us. Okay, main action strategies, it involves the facets insofar as a court proceedings is concerned. There are fundamentals in which you cannot overlook, ignore. And the overview is that we will be touching a bit on pleadings, interlocutories, and these interlocutories, aside from the pre-action strategies that would have already otherwise been considered, preparation for trial, and settlement considerations. Now, a bit on pleadings. Your case entirely depends on what is pleaded. You parties are bound by their pleadings. So it is elementary, it is fundamental to ensure that when you are preparing the statement of claim, that careful thought, strategy, input is put together. And the idea is always, as I share with litigants, that always work backwards, always expect your case or imagine and pretend your case going up all the way to the federal court, the highest court, and working backwards there. When you're in the federal court, more often than not, there always will be issues raised of what was not in the pleadings, or what was the pleaded case, and how parties are deterring, or deviating from the pleaded case. So that is the single most important document. And in IP litigation, it is very fundamental to keep the premise of the claim tied very closely to the causes of action. And that's why you have the causes of action and very clearly spelled out as such, whether it is a trademark or the type of IP infringement that we are dealing with. All of it differs. What is the premise in which we are seeking the claim? Is it statutory? Is it under common law? As you can see, something like passing off, breach of confidence, unlawful interference with trade. These are common law actions, sometimes more often than not premised on tort. Is it an issue arising out of contract? Even that is the cause of action. So it requires you to go in very careful process at the start, because it is considered to be one of the more, if you ask me, one of the most important aspect of the process of litigation. There is always said that the strength of the writ, the strength of the statement of claim, if it is read by an opposing counsel who's going to advise the defendants or prospective defendants, ought to advise on settlement if the strength of the writ is glaring from the very beginning. So there we are with, insofar as causes of action are concerned, you ought to craft it carefully in saying that with sufficient detail, with particulars. More often than not, you are met with parties are met with situations, or the court is met with a situation where they have to look into a case and strike it off because the pleadings are embarrassing. It does not contain sufficient particulars, thus not giving rise to the cause of action that the plaintiff claims that it has. Okay, moving on. Next is, of course, once you filed your pleadings and then the entire pleadings are closed, you have a stage in which you ought to consider any other interim application to either prevent any further infringement which is going on. That would have been dealt with through an Anton pillar order, but assuming that knowledge is surfacing, information or evidence is surfacing in the course of your proceedings, which you have to attend to, that will require you to run to court again with other applications for either consequential relief pursuant to Anton pillar order or other aspects, either through discovery. Discovery of documents, discovery of evidence, discovery and inspection would be a very, very key interlocutory to consider during IP litigation because of the nature of infringement in itself, which is ongoing, whether there are facets of the infringement, whether there are aspects in which you are not aware of, you thought you were aware of as a litigant from the start, but there are other facets which are discovered in the course of proceedings. So discovery along with interrogatories. The concept of discovery is very simple. There is an ongoing duty on parties to disclose documents. This is the position of the law, to disclose documents from the beginning of the litigation right up till the very end. Many people do not understand the extent of this obligation and requirement, or the requirement of being forthright and candid about this, which means if you have something which is damaging to your client, to yourself, you are still under an obligation to disclose it nonetheless, if it relates, if it is material to the action at hand. Now, more so when someone has written to request for such documents to be given. More often than not, in Malaysia, you will find that parties just very conveniently refuse to give the documents because they expect a discovery action to come or is forthcoming. They go to court and then they say they canvass it through the fact that, oh, the other party does not have documents on this, and this is a fishing expedition. And sadly, based on my experience when it comes to discovery of documents, courts here do one of two things. They do not understand the extent of the obligation of discovery upon parties who are litigating, especially pursuant to Order 24, which is far and wide. And they also do not understand the discretion in how they act as disciplinarians in a process of discovery, in which if a party is failing to disclose when it is an obligation to do so, they ought to be reprimanded. And this features so much insofar as IP litigation is concerned, because an action can very easily be rendered pointless if the court is not playing its role as a strict arbiter. You know, you say, okay, there is a provision in which, for example, if there is reason to believe that this information being sought is sensitive information. But if the party seeking that information makes a case or explains as to why this is material and relevant, or why this is necessary, you know, it is a two-way thing. So there is a provision which allows for the court to have sight of the documents first to see whether the party seeking the discovery of the documents is making any sense or is true in their allegations, before allowing that party to have a look at those documents. Alas, you know, in Malaysia, judges rarely order discovery to be made under that provision. Okay, moving on. Now, trial preparation. What I want to emphasize very strongly on is two things. One is managing the physical evidence. Managing physical evidence. It's not a typical commercial litigation where the evidence just relates mostly to documents, rather than physical evidence of the items said to be the infringement of the IP rights of the plaintiff. So managing physical evidence is something which is very important. More often than not, parties do engage external experts to advise on this, you know, insofar as storage is concerned, insofar as secrecy is concerned. So those are key factors to take into account. Now, and then we have the expert evidence. It is almost a given that when it comes to IP, something such as IP litigation, and it is the law, not only in Order 4T, but even in the recent federal court decision involving Aviasia, for example, you know, when a case calls for expert evidence to be, there was a broadcast case which said this. When a case calls for expert evidence, ought to be decided on expert evidence. Should parties decide not to make the election not to present expert evidence, that will stand against that party, and it will stand against the claimant, the plaintiff, who bears the burden of doing that. So when it comes to IP evidence, if you are required to present expert evidence, and not only expert evidence in one aspect, you ought to look at all these various aspects in which expert evidence ought to be presented to the court, and do so. So And of course, when you look at expert evidence, it's very important to look at the formalities of the rules as prescribed by Order 40. Many litigants overlook this. They think that it's just merely through presentation of an expert report. The expert then comes and justifies his report. And I've had situations in which that, because of the non-observation or non-compliance with Order 40, the report is then expunged or disregarded or not admitted as evidence, because you are meant to have an affidavit as a sworn oath testimony by the expert to testify and say and include the expert report as an exhibit for purposes of complying with Order 40A or rules of court. Okay, up next. Now, the nature of IP litigation is such that when enough pressure is placed, at some point, parties would come to the table to negotiate settlement. And when we are dealing with the issue of settlement, there are these key things which ought to be taken into account as precursors or as the premise in which the settlement agreement or prospective settlement agreement would be drawn up. And this will include the extent of the bargaining power as well. And insofar as assignment is concerned, of course, it would generally lean towards the party who's making the claim, but that may not always be the case. These are somewhat self-explanatory settlement considerations. And what is key is that in considering each and every one of this, it is the preservation of the value of the intellectual property that will be central to the core of the decision. Okay, up next, what do we have? So as a recap, and it goes back to the fact, ultimate fact when it comes to an adversarial system of justice, and that is what is the evidence which is presented to the court. So in cases of IP litigation, it is always that key evidence. The key evidence is more often than not in the physical form or in a documentary form that ought to be identified at very early stage, and the case formulated around that. And in the cause of it, in the cause of proceedings, there ought to be thorough consideration given to the preservation and management of the key evidence. And there we are. The final thing is the value of litigation is not so much of setting an example or recovering money per se, but it is to enhance or devalue the IP at hand, to affect and the effect it has on the supply chain. Okay, that is about all what we have today. I will be taking a few questions, and let's see, what do we have as questions? Stephanie.
Yeah, thank you so much, Rishi, for this very insightful session. I personally think that the discussion is very informative and a practical one, which is mostly derived from your experience in civil litigation. I think you are definitely the suitable person, if not the perfect person, to speak on the topic. Okay, the first question we have here, hold on, yeah. Okay, one of our attendees asked, how does one secure an Anton pillar order from a procedural perspective?
From a procedural perspective, what you will run back to the fundamental principles again. Yeah, Stephanie, the thing is, it goes back to the Order 29A. Everything is stated there insofar as observation is concerned. Now, and when it comes to Anton pillar, more often than not, it'll be ex parte, it will be by way of certificate of urgency. So then you have Order 29 Rule 2A to say you have to explain why ex parte, why there is a sense of urgency. All of that must be done, and the court will very strictly go through all of that. You see, over and above that, then there is, and all what is always subject to attack for someone who is claiming an Anton pillar is that they do not go full and frank, they do not go under the premise of full and frank disclosure at the very start. And then that's picked out by the opposing lawyer when they want to argue the inter partes hearing. Evidence required to prove the necessity of the grant of the Anton pillar. This is what I was saying. Every time when we're coming to court to ask for a relief with the absence of the other side, we have to show almost very overwhelming basis to do so. And that Anton pillar is one such thing. The other one, of course, is when you're going for something like a Mareba injunction, it's a freezing order. What is the evidence of dissipation? Just to give a feel of the extent of the threshold when it comes to Anton pillar. So, we had a case, there is a case on point when it comes to this, I remember the case fully, but I think it's something to the effect of Computerland Corp. It is a Singaporean case, actually. It's not fairly recent. But the Court of Appeal took the view that the evidence of breaches of agreements, such as the underpayment of royalties, underreporting of sales, and refusal to allow access to the accounts or to allow an audit, it was not synonymous with dishonesty, and there was no indication of any intention on the part of the alleged perpetrator to destroy evidence. So because of that, they were refused Anton pillar order. So it's very important that the criteria are met along those lines with care. So that's all about what I have to say about that question.
Thank you, Rishi. Having shared the procedure on how to obtain an Anton pillar order, there's one attendee asked the question on how do we set aside an Anton pillar order?
How do we set aside an Anton pillar order?
Yeah.
When you say set aside as an Anton pillar order, we would look at the key is always these few things. It goes back to the full and frank disclosure. When it comes to parties litigating a matter, more often than not, the party making the claim would not want to say certain things, or forgot to say certain things, or there may be other various reasons they didn't want to say it because they felt it was not relevant, So when you are trying to set aside an Anton pillar order, you identify what are the areas in which you can canvass to say these are things which have not been disclosed to the court, these are material, these would show why the basis in which the court was moved for the application for Anton pillar was not pursuant to an absolute disclosure to the court of all the circumstances. And courts, if they buy into that, if it is with basis, not simply, of course, everyone will try to say there's not been full and frank disclosure, but if it is not material, if nothing really turns upon it, there is no footing on it, the courts will disregard. But if there is, not only would the courts set aside, but the courts will frown upon the litigant. You see, when you come to court without clean hands, not with clean hands, it will always work adversely against you. But that has always been my experience in terms of observing litigation for the past decade. Then the other thing would be it goes back to the principles of injunction. As laid down in Keith Gerald, say the typical points which will be raised is that the balance of convenience lies in favor of not granting the injunction for various reasons, because sometimes it can affect a level which is ongoing, so people are on payroll, so these we considered as well. The other thing would be the undertaking of damages. Every injunction will always have this as a very, very huge highlight, and that is the undertaking of damages. And it is more often than not the case that is downplayed by the person who's seeking for the injunctive relief. When you are seeking for an injunction, it's a two-way thing. And this is where the role of the courts are important as well. When you are seeking for an injunction, you're giving that undertaking that if my injunction is wrong and the other side has suffered any damages, then it will be met with such reparation. That is the exact word to use. So reparation will be something which the court will undertake as a very detailed assessment. Should there be damage, and when the other side is seeking to set aside, they present the evidence. So this will be a very important thing to look into. And that is another way in which it could be set aside. But of course, it again goes into what is real. It's just not what is you are claiming that as a fluff. Oh, my company suffered because of this, but it's just a mere statement on the surface. Everyone does this, of course, when it comes to a back and forth in an injunction. But if you substantiate every aspect of it, these are things which could be used to set aside an injunction and to get an injunction as well. Yeah, that's about all I have to say about that.
Thank you, Rishi. The next question would be, how is a springboard injunction different from a confidentiality clause?
Springboard injunctions are not confined to cases of breaches of confidence. They may be granted in other breaches of employment contracts. Yeah, this one recently, because I've been doing a lot of reading, this is something which I've not dealt with as a litigation lawyer. I've not dealt with a springboard injunction per se myself, but I've been reading on it recently, and that there is this case which is on point. It's an English case. It's called UBS Wealth Management, I think. Yeah, and in short, what was held at in that case is that when it comes to springboard injunctions, it is available to prevent any future serious economic loss to a previous employer caused by former staff members taking an unfair advantage, an unfair start of any serious breaches of their contract of employment, or if they're acting in concert with others, for example. So again, this goes back, it ties back with the whole trade secrets as another cause of action, and confidentiality as an issue, tying back to conflicts of interest, duties owed to the company as a fiduciary, so on and so forth. That's all, Stephanie.
Thank you, Rishi. We have an attendee who wants to know what if we can't produce the physical evidence due to missing, etc.? Any other alternatives to prove our claim? Missing evidence.
So what could be considered pre-action discovery applications as well. But that's a separate proceeding by itself. That means you're filing an action specifically to obtain evidence. This is, of course, something which requires great assessment exercise insofar as identifying what is the basis of saying they have this missing link, or the party has these missing links of evidence, and so on. So that is one method you can do just before you start the action, assuming you have exhausted all of that and you don't have evidence. Testimony of individuals could assist as well. If you know for a fact that there have been a mass amount of people who have been working for these infringers, but who are willing to come forth and give evidence, which is unlikely to be the case in a practical sense of it, let me tell you, because more often than not, infringers are people who are involved with illicit, illegal activities. They are underworld, they have underworld connections, they are underworld parties, and no one wants to come forth to testify on this. But if you have that, then it's not the best type of evidence to present to court for your infringement action. You should definitely have some other main core evidence to show what is the infringement. And always, that's why that's the physical evidence. You could use these to facilitate your claim as well. Testimonies from individuals. That's all, Stephanie.
Thank you, Rishi. Going back to Anton Pillar order, our audience asks, what are the pitfalls to avoid when applying for an Anton Pillar order?
Well, pitfalls, they're twofold if you ask me. When it comes to IP, when you're looking at an Anton Pillar, when it comes to IP, more often than not, it is a lack of no proper consideration given to the fact that you have to have very comprehensive investigations done at the start. So when there is a lack of thorough investigation, that will be your main pitfall. You will be caught in a situation in which you perhaps want to passionately argue to say why you are a party who is suffering from a wrong, but you are unable to explain with sufficient detail and through reference to cogent evidence to establish the basis in which you say, I'm moving the court, because you look at it, it speaks for itself. So the weight of the evidence which serves as the basis for moving the court for Anton Pillar, it will go back to the extent of the investigation which was done before coming to court on that. Granted, it is difficult because sometimes the time constraints will be the issue. These are parameters and these are the considerations and variables you are working with, but that is the fact of the matter. When you present to court, because it is a circumstance and it's the fact that we are rushing to court, this is happening and we need to stop it. So, but because of that, we do not have the evidentiary basis to do so. You can't come to court and say that. So, but these are very simple. It is a very delicate, intricate situation to that extent. You need to have the basis to move the court for an Anton Pillar order. The other thing would be, of course, inattentive drafting. Why is drafting or lack of proper drafting, sufficient details and particulars an issue? People are more often than not working against time. There's always an urgency issue. So more often than not, when you see applications for Anton Pillar orders, ex parte injunctions, you'll find a few things missing, things not put in the proper context of it. And this because you're working with the human factor involved. But again, the court is constrained to look at what is before the court. So that will be the fact of the matter. These are general pitfalls, Stephanie.
Thank you, Rishi. I think is that all for today? I think
I'm rather beat. I will leave it at that. If anyone else has any further questions, we will endeavor to answer that through either a legal focus or through an email. Thank you everyone for listening.
Thank you,
Thank you for your questions. Thank you, Stephanie. Thank you very much for moderating this. Yeah.
So with that, I think I will end this session. We'll see you in the next webinar. You can find updates from our social media and Facebook, Instagram, and also LinkedIn. I think we should end this session. Thank you, everybody.
Thank you, everyone. Bye-bye. Have a good day.